is going to be a spoiler, you may as well have them come to the mediation, because if, as soon as somebody gets home, you know, dad or the person who's financing this or the new husband or whatever is going to say, you know, you can't do that, you may as well have had him in the session so that you get their buy-in along with the rest of it. So especially as you start to add parties, it gets to be very, very complicated. So that's the reason that, or some of the reasons that we do it all together, 2 people in the room at any given moment. Another reason to do it that way is that if people get to be too hot under the collar and need to split up, we try to keep people in joint session as much as possible, because they're the stakeholders, they're the ones living with the outcome. A lot of burned out lawyer mediator types will put people in 2 separate rooms, because actually lawyers are by their nature conflict averse. So if I don't have to deal with the 2 of you sitting there together, you look concerned about that. It's true. Because our answer, as the way, based on our training, is, well, if we don't have an agreement, then we're going to go to court, and then we'll let somebody else decide. I don't have to internalize this conflict. I don't have to deal with it. I can just shut it down and say, okay, then fine, we're going to court. You know, slam the table and storm off, which may look like it's courting conflict, but not really, because what I'm really doing is avoiding the conflict itself, and I'm just trying to hang my hat on the legal issues. When, particularly in family law matters, they just don't have that much to do with it. You know, I was early in my mediation career, I was dealing with some folks in Los Angeles, and there's this garment district downtown, and there are these little tiny shops, and it's just this kind of crazy hodgepodge of different kinds of like fashion type stores and just all kind of crazy stuff. You'd think you're in some foreign country. And the issue was that this store tenant had not paid his rent. But the owner of the property was like, look, we got to make a deal here. You know, here he is in the catbird seat, right? He's going to win legally. But he says, you know, everybody in that little neighborhood knows each other. If I get the reputation of being a real pain in the neck on these kinds of things, and I don't work with people, then nobody's going to rent my space. So I have to realize what the emotional impact of what it is I'm going to make a deal doing here is. So if I get the reputation of being a very reasonable person to work with, then people are going to want to rent my space, as opposed to just hanging my hat on the law. And, you know, frankly, in those kinds of instances, generally if people have the rent money, they will pay it. So they're probably judgment proof, or, you know, you may or may not be able to collect later. So
I started asking some questions here because
sure.
And in particular, I'm particularly interested in a few things. And folks, if you want to raise your hand and jump in here, but there's a few things that I'm particularly interested in unpacking. So you moved to California 10 years ago.
Yeah.
And you've had this rough experience as a family lawyer on the East Coast, and you moved over to the West Coast, and you wanted to do things differently. And you had included it in one of the readings that Diane had actually sent along, was this open letter from a divorce lawyer. And you know, everybody says in this course that the readings are very depressing, and they are. And this is a depressing reading from the point of view, but there's actually a pedagogy behind it. And the theory behind the pedagogy is there's another side of the story. It's how do you react to the realities that you confront as an actual practitioner. And I'd be interested to know your mental state when you said you had actually related to this open letter to a divorce lawyer. So I guess a couple of questions related to this. You had seen so many family law cases by the time that this letter had crossed your desk, or I suspect you felt this letter years before you actually saw it. So a couple of things I'm particularly interested in, that the class would be interested in, is that when you see so many, like say me and you are married and we get divorced for the first time, it would be our first divorce. In my case, it would be my first divorce. I won't pretend to know your situation, but the thing is, it's a novel, traumatic experience to go through the first time. But as a divorce lawyer, you've seen a million of these things. You've seen, it actually says that you've mediated over into the thousands of these things. So you get a feel for how these things play out. So I'd like to know from your reaction to these difficult situations where you feel like you're not really adding value to the situation, to how, kind of as a practical matter, you decided to set up peace talks, and in addition to that, how you do things like co-mediate with a psychologist. It sounds to me like you almost have to invent that. That it's not an established form of mediation. Collaborating with a psychologist, it's very much an art rather than a science. That's what I'm thinking.
Yeah, I mean, I really identified with this open letter from a divorce lawyer. I actually got a great piece of advice, too, when I was a student here from an estates attorney who worked for Bank One. And he said, just be really careful about the golden handcuffs, that you'll be driving the big car and you'll have a couple of kids and you'll be staring a college bill in the face, and you'll realize that you can't change your life and your job even though you hate it. So to be really careful not to get yourself sucked into that. Thankfully, I had listened to that pretty carefully. So when I really identified with this open letter from a divorce lawyer, where really the whole system is telling you to do it the opposite way you know to be in the client's best interest. And that's really ultimately what made me crazy, is a client would say, I want you to, come out with both guns shooting, I want you to do this, I want you to do that. And I would know that it was not in the client's long-term best interest to do whatever it was, file motions or propound discovery or do a bunch of stuff. I can't tell you how many private investigators we hired to do Social Security checks, to see if people had hidden bank accounts and all of this stuff, when it was pretty much physically impossible that, say, a policeman earning $50,000 a year in a very modest middle-class house, really, unless he was on the take, right? There's no way that this person had hundreds of thousands of dollars saved somewhere, but the clients would be so full of revenge and so full of disappointment and grief and everything else that they would ask you to do all of this crazy expensive stuff that you knew was not in their long-term best interests. And so for a while, as a younger practitioner, you fight that. You tell them, no, now today you feel like filing all of these motions in court, but really all that's going to do is stir the pot, and your spouse is only going to get angrier at you, and then you'll get angrier in return, and then the whole case escalates in a way it really doesn't need to escalate. And the client says, I thought you're on my side. I was once fired, actually, from a case. We were doing a deposition, and I made the man cry. I've got a 50-year-old man in front of me, and he's bawling, and I pushed the box of Kleenex toward him. Well, his wife fired me because I was being too nice to him by giving him a Kleenex. Meanwhile, reduce this person to tears. No, that was all forgotten. And then the other issue is you'd be doing all of this stuff, and then the client would, at the end, realize that it wasn't necessary, that it was a bad idea. They would, in retrospect, change their mind and devalue what it is that they had demanded that you do, and that they had protested that, oh, you must be on the other person's side if you're not going to do this. And then at the end of the day, they wouldn't pay for it. So then you end up chasing it in a family law practice at any given moment about 20% of your fees. So I actually could have taken one day off a week for all of the uncollectible fees that I had. And this push and pull of what I knew to be the right thing to do versus what the clients were asking me to do, and the pressure to do what they were asking me to do, and then knowing at the back end I wasn't going to get paid, really started to wear on me. I mean, it was just awful. And so, not getting caught up into the golden handcuffs and not being in a position where you can't change what you're doing based on, because you've made a bunch of other commitments, is really pretty important. Yeah, that open letter from a divorce lawyer, if you haven't read it, do. Because it's a very eye-opening look at what people get themselves into, and particularly in family law. I mean, one of the other issues with peace talks is we do as much as we can on a flat fee. So I belong to a lot of these family law listservs, and every once in a while people will ask, what do you charge to do whatever? And I put in my 2 cents that we do as much as we can on a flat fee, and that all of our judgment drafting is on a flat fee, and this is on a flat fee, and that's on a flat fee. Because I think clients should know if they can afford something before they buy it. I mean, that's the way I shop, certainly. But the way most lawyers operate is, well, I don't know, it depends on the complexity of the matter. And after 20 years of doing this, I can about figure that most judgments take me somewhere between an hour and 4 hours to draft, and I take the median of that, and then people can decide for themselves whether they can afford it and whether they want it and whether they think that's a service that they need. So once in a while I end up working 6 hours on something, and once in a while something takes me, I don't know, it takes me really less than an hour, but sometimes sometimes I win, sometimes they win. And, the listserv goes wild because the lawyers just can't get their arms around the idea that you could charge a flat fee for something and that you could estimate. And you're thinking, well, you've been practicing 20 years too. Don't you know how long this stuff takes? Because it's really just it's not that unique in most instances. As the recession deepens, we're going to start to see different issues. Back in the day, we would just, if you can't agree on what to do with the house, you could just sell it and divide the equity. If you want to refinance it, even though you haven't worked in 15 years, you can just go get a loan someplace and refinance it and don't worry about it. And now we're starting to see our first people moving into their folks' basement with the kids. We're starting to see our first upside-down houses. That's only magnified